Thank you very much, Leslie, and thank you very much to everyone who's taken the opportunity to come today. I really appreciate it, and I really would like to thank you for giving me your time. I'm going to be talking about the issue of complainer anonymity in Scotland, which is obviously a legal issue on the one hand, but an issue with much wider resonances about the practice of a range of criminal justice institutions, not just the courts, but I know we have a range of people here from Rape Crisis Scotland, the advice that you're able to give complainers, the confidence you're able to give complainers about how something as fundamental as their identity being disclosed in public is regulated by law. So what I'm going to be doing is really beginning with more of a sort of personal story about how this came to my attention, how I came to be interested in this. And then I'm going to expand a wee bit on the position as things stand in the UK in terms of this issue of complainer anonymity. And then from that, expand out further and look at other comparative jurisdictions, countries that are similar to our own in terms of how they do criminal justice, and look at how they deal with this question of complainers in sexual offence cases, their identities and names finding their way into the public domain. And at the end, I'm going to talk a wee bit about something that we're doing at GCU. My colleague Sinead Stevenson, our students and me are engaged in a campaign to try and change this area of law. And I suppose that takes us on to the substantive point here. That in Scotland, as this meeting kind of is straplined with, we don't have a right of complainer anonymity in Scotland. And I think that fact is something which for many, many people, even very eminent people, even people with a range of experience of the justice system, tends to come as a surprise. It tends to cut against people's expectations about the rights they assume they already have. And that's really where I began my engagement with this topic. And it was prompted by a story which continues to dominate the Scottish political news at the moment, the prosecution of the former First Minister Alex Salmond on allegations of sexual offences. And it was in the lead up to the commencement of that trial, and before it had even started, that I had a conversation. I had a conversation with an editor of a national newspaper who said that the Crown Office and Procurator Fiscal Service had been in contact with a range of media organisations in Scotland, and that they were concerned more than a year ago now that a newspaper, a publication, might identify one of the complainers in this extremely high-profile case. Now, my first reaction to that was, well, why would they be worried about that? Because surely that's contempt of court. Surely that would cut against a right to anonymity, which if you read newspapers, if you listen to the radio, if you watch television discussions around this, you endlessly hear the mantra repeated. In the UK, complainers have an automatic lifelong right to anonymity. And so that question and that reflection with that newspaper editor gave me a measure of anxiety about my own understanding of the area of law and also the implications of that anxiety in terms of this most high profile of sexual offence prosecutions. But I thought, I'm a law lecturer. If there's law in this is within my capacity to find. And so I went away to find the bit of Scots law that says complainers have an automatic right to anonymity. And I looked in all the places you would ordinarily look. I looked in the Bibles of, Scottish jurisprudence on this, but nothing. The Criminal Procedure Act says nothing about it. And then I went to the legislation that covers England and Wales and did indeed find crystal clear provisions, which I'll describe in a wee bit more detail in due course, making it clear that from the moment a complaint is made south of the border, and indeed in Northern Ireland, that a sexual offence is alleged to have been committed, that from that point it is a criminal offence to identify the person who is involved as a complainer in that case. And when I combed through this legislation, I discovered it didn't extend to Scotland at all. It didn't extend to Scotland at all in terms of Scottish cases. And therefore, the impending prosecution in this very high profile case was one in which the complainers' identities, as a matter of law, had no automatic protection whatever. Now, having established this and surprised myself and cut against all my own expectations of what the law would and should be on this point, I decided, for reasons which I hope are self-evident, to keep this information to myself for a significant period of time, because it was clearly not in the public interest to embark on a discussion of what rights people may or may not have to keep their identity out of the public domain. But with the conclusion of that case, I decided it was time to address this glaring gap in the law in Scotland. How can it be that in every other part of the UK, UK, complainers have an automatic right to anonymity, but in Scotland there is no such thing. And secondly, I suppose, how can it be that we don't know this? How can it be that we're not aware of this? How can it be that the public misconception continues to thrive in perhaps quite helpful ways, that there is some sort of protection in place for complainer anonymity in these cases? And I think we can attribute that to some extent to the role of old and new media. If you go through training in law and as a journalist, if you go through your training in Scots law for journalism, then part of that is a recognition that as a matter of press ethics, you should not identify complainers in these cases. The law may be different, whether you're working for the Guardian down south and publishing in London or working for the Herald in Glasgow, it doesn't matter. As a matter of press ethics in general, the media have said we're not going to identify individuals. And of course, social media formats like Twitter, like Facebook, only really emerge in the middle of the 2000s. And so it's only at that point, really, you get the substantial opportunity for anyone with thumbs, with an agenda, with information about a case which they wish to share, to reach a potentially global audience. And therefore, as in so many other areas of our lives and in terms of the law's response to technological developments, it creates new challenges which didn't exist and weren't anticipated in the years before. And therefore, I think in Scotland it was perceived that there was no real problem here because the media, by convention, by gentleman's agreement, didn't name the people involved in these cases. And therefore, we didn't have to worry too much about the lack of legal protection. That position is, I think, a touch naive, as in fact the Scottish media has identified people, even in fairly recent years, as complainers in a sexual offence case. The most recent example was a case of a man against the Daily Record newspaper. He was a complainer in a sexual offence case which resulted in an acquittal of the accused person in that case. The Daily Record in, I think, 2014 decided to publish his identity in the newspaper. And when this happened, as a consequence of it, the man reflected in his complaints to the press authorities in this way that effectively his family and friends found out about the fact this case even happened from reading about his name in the Daily Record newspaper. He described it as a humiliating experience, and he found that he had no legal recourse and no legal rights to protect his identity in this way. And so really in the wake of that fact and of the precariousness, the unique precariousness of complainer anonymity in Scotland, I wanted to cast a wider look at, well, what are we doing at the moment in the rest of the UK? What other international models are in place for how we might handle this? And I really wanted to get a grip on just how out of step is Scotland with other jurisdictions you think about when you think about criminal justice being done in a similar way. We know it's out of step with the rest of the UK. What about the Republic of Ireland? What about all of the Australian states? What about Canada and a range of other common law jurisdictions with very similar types of features? And really that's what I'll ultimately develop onto talking about in a few moments' time. I should probably be clear though what I'm talking about when I'm talking about complainer anonymity. I'm not talking about secret witnesses. I'm not talking about a trial where the true identity of a complainer in a case is not disclosed. I'm not talking about that. What we're talking about here is reporting restrictions. That's it. So it's about imposing reporting restrictions on the identification of people as potential victims, as complainers in legal terms of sexual offence cases. When can we impose limits on the media, the old school media, but also that emergent form of new media which we know poses particular risks in terms of complainer anonymity, particularly for an organisation or a jurisdiction like Scotland, where the only protection which is available to complainers relies on that gentleman's agreement of press ethics, which the average tweeter, the ordinary Facebooker, is not signed up to and therefore cannot be complained about to. I think that's the fundamental problem in play in this case. So it's not about secret anonymity type cases inside trials. That's an entirely different issue and raises really fundamentally different types, I would say, of issue. Here we're dealing with limits in terms of free expression and the legitimate limits that can be imposed on that in pursuit of wider public interests, including encouraging people to come forward with allegations of crime without facing potential vilification in the media or identification in the media or the humiliation and embarrassment that the man discovered when he read the Daily Record and discovered his case discussed there. Now, if we look at the rest of the UK and look at the position south of the border on this, that complainer anonymity has existed in England since 1976. And at that early stage, it was limited to England and Wales, and was limited to the more obvious ways that you might identify someone as a complainer in a sexual offence case. So it limited identifying their name, where they worked, for example, things that were very obvious, pictures of them being broadcast, all of those kinds of things which very directly identify a complainer. And under the English rules, this right to anonymity effectively accrues from as soon as an allegation is made. So the anonymity is imposed by the law. There's no judge involved in imposing this protection for the identity of someone who says they've been a victim of sexual crime. Over the years in England, since 1976, this has expanded to recognise what's often described as jigsaw identification. And jigsaw identification, as the metaphor probably suggests, is where you don't necessarily name an individual, you don't put their photograph on the front page of your newspaper, but you give people sufficient bits of their identity, sufficient information about them in order to allow an overall picture of that person to emerge and for them effectively, if indirectly, to be identified. And so through reforms in 1999 in England and Wales, this was also extended for all of these types of cases. So it's not simply identification of the complainer in the case, it's anything which will tend to give rise to their identification in these types of cases. So that's the position in England and Wales. There's an automatic right of anonymity from the moment an allegation is brought to the attention of the authorities. In Scotland, by contrast, we don't have any of that. There is no automatic right to anonymity whatever. The courts do, however, have some tools in place which they can use in some cases. And if you're thinking about the recent high-profile case against the former First Minister, you may be thinking about the fact that the complainers in that case do have a right to anonymity. How do we square that with what I've said? Well, under the Contempt of Court Act, which is a piece of legislation with a range of different dimensions to it, the courts in Scotland do have a specific power. In particular cases, if the Crown or the defence apply for it, then a judge can make an order saying that you cannot name or publish information leading to the identification of a complainer in a case. So there is a legal route to securing anonymity in a legal sense, and breaches of orders under the Contempt of Court Act are criminal offences. In the Salmond case, for example, a man who identified 5 of the complainers in that case was recently jailed by Lady Dorian for 6 months for having done so. So it does have legal effect, but you'll notice that there are important differences as a matter of practice. In order to get such an order, one of the parties to the case has to apply for it. And the complainer is not a party to the case. In legal terms, they are a witness, and they are not legally represented in that environment. They don't have the chance to be heard in court in their own voices about the need for such an order. It's interesting that in the case involving Alex Salmond, it was only on the second day of the actual trial that this order was imposed in terms of that prosecution. So for the entire period before this, it would have been perfectly lawful for an individual to identify one of the complainers in that case without any type of recourse in Scotland. That, I think, is a very stark fact, and demonstrates the extent to which Scotland is out of step with the rest of the UK on this fundamental question. But we need to look at the practice around this. This is one high-profile case. There are roughly 1,800 prosecutions every single year in Scotland involving allegations of serious sexual offences. Some, I think, 360 or so allegations of rape and attempted rape are heard. You know, how many of those cases benefit from the protection of such an order? Well, looking at the data on this, it's about 8. So 8 cases where you have an order imposed in any given year that the complainer shall not be named, out of some 1,800 cases. So clearly there's a major gap in the protection which is available to most complainers in terms of Scottish cases. And if they do have an expectation of a right to anonymity, then they are fundamentally mistaken about the strength of the protection the law extends to them. So that's the situation which we are in Scotland at the moment. There is no right to complainer anonymity. Complainers are not represented in the court which decides about it, and most people are not protected and can, as we see in the case involving the Daily Record, find their name in the newspaper as a complainer in these types of cases. So My reaction to that is that that is an unsatisfactory position and is in serious need of reform. But in order to understand what kind of reform we might do and how we look in the global sense of legal systems, I cast the net a bit more widely in my research I'm doing at the moment in terms of international sources. And what I've discovered is that Scotland is out of step not only with England and Wales and Northern Ireland and the Republic of Ireland and Hong Kong and India and Bangladesh and Canada and every single jurisdiction you can mention in the state of Australia. You get the picture here. Scotland is way out of step with all of the other kind of major comparator jurisdictions you would draw in terms of how we're doing this. But what's really interesting, I've discovered, is that when you look at Canada, when you look at the situation in England, when you look at New Zealand and Australia, you see different models of protection in place. And I think that raises fundamental questions if we're thinking about doing the law better on this in Scotland. What inspiration we draw from different places and what risks we might be embarking on by recognizing complainer anonymity in a rough and unthoughtful way, and particularly don't reflect on the interests some complainers will have in going public about the fact that they were victims of sexual harms. And really, I suppose we can condense the international picture down to three questions. One, do we have reporting restrictions at all? I mean, are they available at all in sexual offence cases? And the answer is, in most of the countries that I've mentioned, is yes. It's only really in the United States of America you get that First Amendment free speech fundamentalism, which means that if a fact is true and it's said in open court, then there can be no legal restrictions on that. Generally speaking, whether it takes the form that we have in Scotland at the moment of very discretionary orders occasionally granted, or the position in England of an automatic right to anonymity from accusation effectively, there's generally a recognition of this right. But there's a second, I suppose, set of choices which are made by these legal systems about how is the anonymity imposed? When does it start? You know, in England, as we said, it comes in as soon as an allegation is made. So the complainer doesn't have to do anything or know anything or have any resources to be able to, for example, appoint their own lawyers to go to court and make the case for them. That's not true everywhere. A good contrast here is in Canada. In Canada, they introduced a sort of funny hybrid system where effectively a complainer has the right to ask the court to impose reporting restrictions in their case. And if a complainer asks the courts in Canada to do that, then the court's got no option. It has to grant that anonymity to them. So it's a kind of slightly different from the Scottish system where there's no such obligation on the court to grant an application for anonymity. But nevertheless, the onus is on the complainer to do this, to instruct their own lawyers, to make their wishes known. And obviously leaves that substantial gap between a potential allegation being made and an order of the court within which it would be perfectly legal to identify them in public. So we need to make a choice about, do we want a kind of Canada-style discretionary model, case by case, or is it better, clearer, simpler to impose something like the English model in terms of an automatic right to complainer anonymity? As I've summarised that, you can probably guess where my sympathies lie in terms of this. I think we don't want to have gaps in a system as extensive as the Canadian one can sometimes give rise to. And we also have to be mindful of the fact that many people who will be complainers in these cases may not have the awareness and the resources to be able to participate through legal advisors in the legal process. That seems to me unnecessarily complicated. So that's one of the important choices that Scotland, when it comes to reform this, and I truly hope it will, has to make about what we do with complainer anonymity and when it starts. Another thing which is important really is when can you set it aside? When can it be set aside? And this has been an issue which has really bubbled up in a range of different jurisdictions in different ways. I mentioned India. In India, there's an absolute prohibition in their criminal code on identifying a complainer in these cases, unless the complainer in writing agrees to go public. Now, this has been, I mean, the particular context of India, controversial because if the law effectively there says that if the complainer dies, their family is also prohibited from identifying them in these cases. So there have been very high-profile cases in India of people who've been victims not only of sexual violence but of homicide, whose families have been prohibited by law from going public about who they were and the fact that they were victims of these types of crimes. In fact, they've very often spoken to reporters outside of India, but nevertheless, that kind of restriction seems at the very least insensitive to the interests of family members who may well want to reflect on the lives and losses and sufferings that were inflicted on their loved ones. So that's important, I think. Looking at other jurisdictions, this has also emerged as a social campaign issue, generally down in the Antipodes, down in a range of states in Australia, in Victoria and in Tasmania in recent years. We've seen recent campaigns under the strapline of hashtag let her speak, or sometimes also hashtag let us speak. Why did they emerge? What was that about? Well, really, it was partly that social shift towards people wanting to say in public, I'm a survivor of sexual violence. This is what happened to me. We need to talk about this in public. And people who experienced that in the states of Victoria, in Australia, and Tasmania, when they looked at the law, they discovered that it didn't just gag other people from talking about the fact that they were complainers in a sexual offence case, it also gagged them. It would be illegal for them to go public and to say to a newspaper, I want to tell my story and explain what happened to me. And so in response to these rather unsubtle forms of complainer anonymity that were introduced in these Australian states, there were substantial social movements articulated, as the name suggests, on social media to try and challenge this and to create the right kind of right to go public for complainers in these types of cases. If they want to go public, then the law should facilitate that. And it's worth saying that in Scotland at the moment, the Crown can seek an order for anonymity and can make it a criminal offence for anyone to identify an individual as a complainer in the case. But if the complainer does that in social media, if they go public without asking the court to set aside that order in Scotland, they would be as guilty of contempt of court as that man on social media who identified 5 of the complainers in the Salmond case. So we have in our own jurisdiction many of the same types of problems around that the law has not really evolved to recognise the different choices complainers might want to make about the level of publicity in their case. And I think it does take us on to the fundamental question, which I really straplined my article in the Edinburgh Law Review on this, which is publicly available and you can read for all of the legal detail of this, but also in terms of just this presentation today. Why don't we have this in Scotland? And I suppose the correlative part of that, which is, well, why should we have complainer anonymity? Whose interests are we protecting and why? And I suppose for many of us in the audience, I won't need to persuade you very strongly that this is an important interest. This is an important interest in terms of complainer privacy. It's important interest in a wider social sense in terms of encouraging people to come forward and to report the fact that they've been victims of sexual crime. As we know, down the decades and in a range of jurisdictions, that the fear of publicity is one aspect, one reason why people decide not to take forward allegations that they've been victims of sexual violence. And also, I think we can think beyond that about other interests which may be less obvious, but which are also in play. In terms of these types of cases. Miss M, many of you will be familiar with. Miss M was a complainer in a sexual offence case, a rape case in Scotland. That case culminated in a not proven verdict, and she took a civil action to the Court of Session. She sued her rapist in exchange for compensation, and a Section 30 contempt order applies in her case, so it would be a crime in Scotland to identify her. She was talking recently on Radio 4 in the Law and Action programme about what anonymity meant to her, and she made a point which was that it was significant not simply for her but also for her family and for her friends, in the sense the fact that who she is, her identity is not public property, is something which is obviously and understandably of critical importance to an individual at the heart of a case who's been a victim of sexual violence. But but it will also be significant for other significant people in their lives as well. And given that, it strikes me that Scots law has absolutely no business being in this retrograde position of relying effectively on a gentleman's agreement of the media and a wild west of the social media to protect something so fundamental as the privacy rights of complainers in these cases. And therefore, what I had decided to do after having identified this problem and talking to my colleague Sinead Stevenson from GCU Law, who I think is with us today, I decided that it's not really good enough often academically to say this is a problem, someone should do something about it, but instead to try and make the argument that we should do something about it. And so Sinead and I and our students at GCU Law, 6 of our students have been working on a campaign for complainer anonymity over the past few months and going into the next parliamentary session with a view to persuading Parliament and persuading the new Scottish Parliament that this is something which needs urgent reform. It needs urgent change, and it needs, I think, a model based on the rights of complainers to anonymity from the moment an allegation is made. And it needs serious thought about making sure that when we're setting aside anonymity, when people are waiving their anonymity, we have the right rules in terms of that, so we don't risk criminalising complainers twice for telling their story in a courageous way in public. So that's what Sinead, myself and my students have been working on in terms of this. Over the last week, I was very encouraged that Lady Dorian, the Lord Justice Clerk, published her review of the current practice and management of sexual offence cases. And one of her recommendations in that is that Scotland cannot continue with this precarious position in terms of something so fundamental as complainer anonymity. And so she supports the argument that we need reform in this area. And I'm optimistic that in the next Scottish Parliament, given that most people think this right already exists anyway, that we can take Scotland out of its powerless present position and really legislate in a way which fundamentally protects this most fundamentally important set of rights for complainers in these cases. So thank you very much for listening to me. Hopefully that was reasonably clear about the situation. I'd be very happy to answer any questions you may have about anything arising from that or anything else you want to ask. Thank you very much.
Thanks very much, Andrew. Well, I can kick you off with the first question, which I think came from somebody who wasn't able to stay for the Q&A, so I don't know if they're still here or not, but they had posted it up before they left, which was they wanted to raise the issue about journalists getting complainers' names from the indictment and then tracking them down through social media. Do you think legal anonymity could be framed in a way to prevent journalists getting complainers' names in this way?
That's an interesting question, and actually can take us back to one of the international examples that I mentioned, which is India. In India, the restrictions are not simply limited to the public publications of people's identity, that in fact there's a range of protocols in Indian cases where complainer identities are sort of redacted even on official documents and courts are cleared. Now in Scotland we clear courts when complainers are giving their evidence, but if indictments circulate which contain complainers' identities and journalists have access to that, then obviously the possibility of their identities leaking out into the wider culture is inevitable. Here I think you get into some of the challenges though of what is the right level of publicity in these types of cases. Scotland does have a commitment, and it's been recognised by the UK Supreme Court, to a presumption in favour of public proceedings. You know, that's part of Article 6 of the European Convention on Human Rights and an idea of a fair trial. So I suppose the challenging question is what restrictions do we pose in terms of that publicity? And in a European Convention sense, by limiting people's free expression, we need to think about, is it necessary in a democratic society and is it proportionate in circumstances? I think there might be questions raised about the suppression of that kind of evidence and not making it available to journalists, at least to responsibly report. But clearly, anonymity in terms of publications is only one aspect of the range of different ways we can intervene in these cases to ensure that people who don't have to know about the identity of complainers in these cases simply don't know about it, and therefore the risk of it leaching out into the wider media and social media is to some extent mitigated.
Thanks, Andrew. And I've got another question. Not only does Scotland have a lack of anonymity, but the regressive need for corroboration in sexual cases. Only evidence should matter. Should anonymity also be provided for the accused unless public interest precludes?
Well, so there's two dimensions to that. I mean, I would not suggest for one moment that the only problem in terms of Scottish sexual offence cases is questions of anonymity. That clearly is not the case. And if you haven't had the chance to read Lady Dorian's review, I think it identifies a range of really practical things and practical changes which can be made way before we begin thinking about corroboration in these types of cases. And maybe just to give you a brief summary of some of that, if you're not familiar with what Lady Dorian recommended last week, the main recommendation which prompted the most reporting in the media was the suggestion that we should run effectively a pilot trial process which doesn't involve juries in serious sexual offence cases. At the moment, every single rape case in Scotland is heard by a jury of 15 people, and much of the attention focused on that for understandable reasons, perhaps. But moving towards a situation where Scotland has a national specialist court dealing with sexual offence cases, which has trauma-informed staff at every level, which involves advocates who are appropriately trained, whether representing the defence or the Crown, in trauma-informed responses, that judges who are presiding in these cases have the appropriate training, that kind of backstage staff of that training, seems to me very, very sensible and very constructive, and will avoid indirect, accidental, thoughtless, careless, to some extent, additional injuries and additional traumatization through people giving their evidence in these cases. Lady Dorian's other major recommendation was to extend the use of pre-recorded evidence. And I know Sandy Brindley was with us here before. I think she had to leave early, but she made the point to me many moons ago, and it struck me very profoundly, that delay might strike the average witness in many cases as a minor inconvenience. But if you are a complainer who is coming to court and psychologically preparing yourself to give evidence, arriving at court only to discover that your case has been delayed, and then having to go back home and go through the process again and psych yourself up for another day only to discover it's delayed again, and that's a major and perhaps easily overlooked feature of the justice system for those of us that don't work day and daily with complainers in these cases. And I know that there's many people here who do have that insight and experience into the effect of something like delays here. So the pre-recording of evidence is one way, hopefully, of mitigating that potential difficulty. The question touched on corroboration. I could talk about corroboration an awful lot in terms of these cases. It remains something which the Scots lawyers are very defensive about getting rid of and very defensive about making changes about, but it's simply the case that many, many cases of serious sexual violence and domestic abuse and a range of other crimes that take place behind closed doors are simply not susceptible to corroboration in many cases. And the consequence of the corroboration rule, which means effectively we need two independent pieces of evidence for the essential facts of the case, including the fact that the complainer didn't consent, well, that is a barrier to justice, as Lord Carloway described it. It's a barrier to justice which many lawyers would argue is justified. I personally am sympathetic to changing the rules on corroboration for cases which do take place in private and where corroboration simply isn't reasonably available. I think what's good, though, about the Dorian position, what's good about the report, is it begins to open up a slightly more radical discussion about how are we doing criminal justice in this country, and in particular, how are we handling these sexual offence cases, and do we need to embark on an analysis in a way which is controversial, and rightly so, about how we're doing pretty fundamental things, rather than simply saying, well, a 3% conviction rate in the global picture is just something we have to live with, which is basically the argument for the status quo.
Thanks, Andrew. I've got another question for you. Do you believe removing juries from sexual offences cases would be beneficial?
That is the controversial question. I'm probably more sympathetic than most practitioners are to this. Clearly, many defence lawyers would perceive it as an attack on the fundamental rights of the accused person to a fair trial and to a trial by their peers. I suppose I'd make a few points about that. Firstly, trial by jury doesn't happen an awful lot in Scotland. I mean, if you object to trial by jury, then you're objecting effectively to what, about 96% of the trials that take place in Scotland, most of which take place before a judge alone. I see that from a kind of first principles position, that there's an argument many people would say that given our tradition of criminal justice, the most serious cases with the most serious consequences for individual liberty should be the subject of a jury trial. And I respect that argument. What I would say, though, is that most of the evidence that I've encountered in terms of the dynamics in jury rooms, and much of that is drawing on mock trial work by a range of academics. I think James Chalmers from the University of Glasgow is maybe with us today. He's been doing the Scottish Jury Project along with Fiona Leverick at the University of Glasgow and Vanessa Munro, looking at the dynamic of jury decision making in these cases, and particularly looking at, you know, what is the impact of often biased, confused attitudes towards consent, to female sexuality, to blaming of victims. We know all of that is a factor in these types of cases. This week on BBC Radio Scotland, a defence agent who I generally have a lot of respect for, turned up on the radio and said that there's no evidence that juries believe rape myths and that rape myths are themselves a myth. I found that a remarkable proposition, as it goes against a range of research, a substantial body of research, which shows that some jurors, not all jurors, but some jurors who are tasked with these decisions in these cases will bring with them, inevitably, as they are part of the culture. That's why they're there. That's why we defend juries much of the time, that they have an insight into the wider world and how people live. They're going to bring with them attitudes, some of which will be profoundly problematic on questions of consent. And therefore, I think if you're going to defend juries deciding these cases, you have to accept that as a feature of the system. And therefore, if you're not prepared to accept that and don't want that a feature of the system, well, judge-based trials might be a way out of it. After all, one of the issues we can deal with much more straightforwardly with judges and with advocates is training. You know, you can do that with a fairly limited body of people with a consistent engagement with sexual offence cases. You can't do that with a randomer taken in off the street to decide a particular case. So I think it's going to be an extremely controversial proposition, but I do think, given the weight of evidence we have about the disproportionate impact which rape myths can have in these cases, that we really do have to be serious and talk seriously about whether we need to do something more fundamental than tinkering around the edges of the criminal justice system, which is largely what we've been doing in recent years, whether it's introducing statutory jury directions that say the judge has to tell the jury at the end of the case that simply because there's been a delay in reporting, it doesn't mean that the allegation is false. Simply because there's a lack of physical resistance doesn't mean that the allegations are false. I mean, they've been introduced and no study yet's been done on the effectiveness of those, I think. But it does strike me that much of what we're doing here is tinkering around the edges and not addressing fundamentally the problem, which seems to be in play in a number of these cases.
Thank you, Andrew. Another question for you. Given that complainers don't have a right to independent legal representation on this matter, is there any provision under existing Scottish legislation that you know of to seek a court order preventing naming or other measures that might help if, for example, a complainer is being repeatedly named on social media?
Yeah, that's a good question. I think if you were a complainer in say a pending sexual assault case and you did apply to the court, they would be sympathetic to the proposition of protecting your identity. I mean, Lady Doreen, the Lord Justice Clerk, in recent judgments around this has reflected on the importance of complainer anonymity in these cases for a range of interests, as I've said, for the complainers individually themselves, for their family and friends, but also in the wider justice interests of cases being able to be brought forward and forms of effectively intimidation not taking place. So I think it would be possible to apply as an interested person, as a complainer in these cases, to for an order to be made. But of course, that requires the complainer to know that they don't have a right to anonymity. And in general, in my experience, people don't know that that's the case and therefore don't have that sense of initiative because they assume they already have such a right. And I think a much cleaner way of doing it would be to embrace the approach that you see now effectively in all the Australian states, in New Zealand, in the Republic of Ireland, in England and Wales, which is simply to make it a matter of law and therefore not to turn it into a kind of roulette situation about whether the individual complainer has the wherewithal, the resources to really intervene in their own case. I mean, the question of independent legal representation is a really interesting one and has a range of wider resonances about different stages and moments in the criminal justice process involving sexual offence cases. Just last week, there was a decision of the appeal court, which is very significant, about the operation of rape shield rules in Scotland. And as you might be aware, there are legal rules in place in Scotland, often referred to rape shield rules for shorthand, which limit the ability of the defence to question a complainer about their character, things like their sexual history and so forth. And so they've existed for a number of years, a substantial number of years, and have been unreformed in Scotland since 2002. But for much of the time, these applications were made by the defence to question complainers on prohibited topics. You know, the defence have the chance to apply to question about character, to question about questions of prior sexual contact. And for much of that time, judges on the evidence, Michelle Berman did a study about this in 2009, were effectively green lighting the questioning of complainers on these prohibited topics. The rape shield rules were proving not all that much of a protection to complainers in practice. However, I think since around 2013, 14, 15, under the leadership of the current Lord Justice Clark and Lord Justice General, there's been a real sea change in terms, I think, of judicial attitudes towards applications by the defence to raise questions on collateral matters in these cases about the complainer's character. But this case that was decided last week is important because it's really about the communication, because we know that's one of the major failings for a range of different actors in these cases. Communications by the Crown to the complainer, the quality of information that they're being given, the consistency of it. In this case, it's called RR against Her Majesty's Advocate. A complainer applied to the appeal court because the judge in that case had granted the defence authority to question them on these notionally prohibited topics. And the complainer hadn't even been told that that application had been made, never mind had the chance to express her own view about that. And so the complainer's legal action was arguing effectively that in order to protect her fundamental rights to privacy under Article 8 of the European Convention, and questioning her about these prohibited topics should self-evidently engage questions of her privacy, that she had to be not only informed about the fact that an application had been made by the defence to question her on these prohibited topics, but also that her view should be heard in the courtroom, that she should have the chance to participate or to be heard at least in some form in terms of the decision making on this question. Now, as we've said, you know, that the parties in front of the court are the Crown and the defence, and the Crown are not the complainer's lawyer. Their interests may not straightforwardly align with the complainer's personal interests at all, and you'll be aware perhaps of other attempts to get complainer representation recognised by the Scottish Parliament, legislated for, and also critically appropriately funded by legal aid. What the court held in that case last week was that in order to uphold these fundamental privacy rights, the Crown now has an obligation to tell the complainer that an application has been made, to question them behind the rape shield rules. And the Crown also has an obligation to present their view in court around decision making about it. Now, that won't be a major sea change in some senses. The complainer won't be there arguing the case in court through their lawyers, but nevertheless it means that the information that basically questioning on their character is going to be part of the case, and their view on whether it should be allowed to be will now be a mandatory part, as a result of the European Convention on Human Rights, of decision making on these rape shield rules. And I think that's also, in addition to the Dorian report published last week, a significant innovation, change, improvement in terms of our handling of that. It's only one part of the information exchange which is so important in these cases, but a really important one, I think. And in the next Scottish Parliament, maybe a range of parties will be more sympathetic to full and proper recognition, as a number of other academics, Eamon Keane at the University of Edinburgh has argued, for complainers to be actually represented independently in court, not simply presented, if you like, by the Crown. But progress nonetheless, I think, on that.
Thank you, Andrew. So I've got two questions that overlap a little bit, so I'll present them to you both at the same time. One main challenge in dealing with social media is the existence of anonymous accounts and trolls. Social media companies have not been open to releasing the information of these individuals. How can we approach this? And how do you think or hope the anonymity would work in regard to social media? If someone publishes the name on social media platform, are they prosecuted, or does it then fall to the social media platform to do something?
Yeah, two very interesting questions. On the social media platforms and their regulation, that's just a global issue, isn't it? In terms of a range of different interests that are involved here. The kind of Wild West sense of the web is one of its strengths, I suppose, on one level, that it's not susceptible to some of the strict controls we see in some societies, but at the same time has the ability for individuals to act in a way which prevents them being held to account. Well, we can look at other jurisdictions to get a sense of this. You know, in a range of places in England and Wales, you have you have rules in place protecting anonymity, and yet people, of course, will still break those rules. I should maybe point out the fact that the guy who was jailed for 6 months by Lady Dorian was jailed for his use of his Twitter account. So there are ways of identifying people who are involved in identifying complainers in these cases. But will you be able to identify everyone who does so? No. Probably not in reality. I think we have to be sanguine about that. But I think there is a responsibility on social media companies to address this. And that's actually one of the interesting secondary problems of our current situation. And this is not principally, this reform, this idea, this kind of call for change is not mainly about the prosecution of the former First Minister. For me, it's much, much bigger than that. But his case has illuminated, and the fallout from the case has illuminated a range of the weaknesses, I think, in the structures of law that exists at the moment. And in that case, one of the complainers, whose name and identity is protected by court order, was identified and complained to Twitter about the post in question. This was reported in the Daily Record newspaper. And having complained to Twitter, Twitter asked them for a copy of the court order. Before they acted, and therefore their name remained identified in the public domain far longer than it would have been otherwise. You know, and it's not the complainer's court order. It's not their order, it's the Crown's order. It protects their identity, but it's not their order. You know, at least in England and Wales, you would say, you know, it's automatic. So there are kind of secondary weaknesses, I think, of our system here by the fact that people like social media giants will make demands of complainers for copies of orders and things to remove their identity from the public domain. And that seems to me very unsatisfactory. But ultimately, all we can do, I think, is have the right criminal law in place to protect people's identity, have rigorous enforcement in cases where it's identified that there has been a problem or a breach of that, pressure put through not simply political means, but in the wider political sense on social media platforms to really recognize the power that they hold, and as a consequence, the responsibilities that flow from that power, to uphold something as fundamental as this. But are people sometimes going to take to social media to identify people for whatever personal reasons they have? I fear that is an inevitable thing. But all we can ensure is that we have law in place which can give meaningful legal assurances that that's not on. And at the moment, we don't.
Thank you, Andrew. Another question, is there a cultural barrier to extending anonymity to more complainers? In an age where we're used to being able to access information as never before, protecting complainers' anonymity is perceived by some as suspicious, in inverted commas, and opaque, in inverted commas, with complainers, in inverted commas, hiding behind anonymity.
Certainly, that's a discourse you sometimes hear. I think actually on the evidence, and I hope to improve the evidential picture on this in due course as the study goes on. But my feeling is that the Scottish public and the public in general are sympathetic to the proposition around this. I don't think that there's a substantial majority of people who would resist this as an idea. I think the fact that people already talk as if we have an automatic right to complainer anonymity is reflective of that fact, that people can understand why you would put it in place for these types of cases. They can understand the personal and collective interests which are served by this. And I'd also, I suppose, point to the fact of all of the different countries who already have this, and in the case of the rest of the UK, have had something like this since 1976. It's not a radical innovation, I would suggest. It's something which is effectively Scotland way out of step with where everyone else has been in most of the countries I've mentioned since around the late 80s to the early 1990s. It's when you begin to see really a consolidated picture across the common law world that reporting restrictions should be put in place. I realise I forgot to answer the second part of the last question you asked me there, Leslie, which is about the anonymity for an accused person. And that will invariably come up in discussions around this, and I fully expect it to form part of the discussion as the campaign for complainer anonymity at GCU kind of tries to hopefully have some impact in terms of that. I think I'd make a few observations about it. Firstly, I think the issues are not identical, and it's a mistake to present it as a kind of, if complainers have anonymity, then accused people should have anonymity. Again, not least because most jurisdictions don't do that. Of all of the jurisdictions I've mentioned that do have reporting restrictions in these cases, you know, all of them, only one of them, I think, has reporting restrictions in terms of the accused, and that's the Republic of Ireland, which has moved to that position. So in Ireland, there is effectively an automatic suppression of the names of both the defendant and of the complainant until the conclusion of the case, and the accused person's identity is only disclosed if they are convicted, is my understanding of how that works in Ireland. So there are some places that do recognise that, but most people would say that I think they are two separate types of issues, and the arguments for complainer anonymity are not identical to those for accused person anonymity. Some people would be even stronger than what I just said and say that actually the publicity around these cases very often is important for bringing people forward as potential prior victims of an accused person. It takes that report in the newspaper for people to come forward. You know, increasingly we know from the way that the police now investigate sexual crime and domestic abuse, partly because of that corroboration issue we flagged up earlier, partly because of what's called the Murov doctrine, the need for mutual corroboration as a way of getting into court, that we will investigate, you know, the prior history of an accused person to try and find that mutual corroboration in cases which are historic or take place in private. We know that's ongoing already, but there will, in some circumstances, be potential complainers out there who are only able to come forward because they see the accused person identified in public by others. And I think that is an argument which weighs against the anonymity for the accused people. In terms of the campaign, I suppose I'm just trying to be laser focused and laser limited and say this is a reform which needs to be made soon, can't be left to fester. And, you know, there is a wider debate to be had about these wider issues of how do we deal with accused persons in these cases.
Thanks very much, Andrew. That's all of the questions we've got in our chat. There was another comment, but it covered social media, which I think you've sort of told us about already. So we've got about 8 minutes left. If anybody has a last minute question they want to put into the chat, then I'll give you a minute or so to do that, just in case there's any last minute thoughts or anything. I suppose while people are maybe just thinking about that, Andrew, I'll maybe sneak in a last one for now. Do you anticipate any resistance?
That's a good question, Leslie. I think yes, I think probably I do. I think the principle of open justice is something which some people are sort of committed to. You know, see in the United States, the idea that we are preventing something that's true reaching the public domain is what we're sort of talking about here. And so some people would prefer that the whole thing takes place in public. I think some people will see it as very much a kind of bounded issue, that if complainers get anonymity, accused people should get it, and if accused people don't get it, complainers shouldn't get it. I think that's one point of resistance. Although I think this is not principally about recent high-profile cases, that to some extent the discussion may for some time have resonances of that kind, which weigh against recognition of complainer anonymity. But I think in general, I think the public is in favour of it. There is some polling evidence that shows the public is in favour of complainer anonymity by majority. Also shows them sympathetic to accused person anonymity, by the by, to be candid about that. But I think in principle the arguments for it are so well embedded in our culture anyway, then it's a good example of the law being miles behind where the public opinion already is on this question. And I suppose I would challenge people that say we shouldn't have this and it's fine as it is. Why? Why? I mean, why does every other comparative jurisdiction I've mentioned feel that it's a necessity to try and encourage this most challenging area of criminal practice, most challenging to prosecute, to work slightly more effectively than it works at the moment? You know, why is it necessary in Australia, in every state and territory? Why is it necessary in Ireland? Why is it necessary in New Zealand? Why is it necessary in Canada? Why do some states in America try and introduce this type of legislation? Why is it needed in Wales, in Northern Ireland, but Scotland Scotland, the special one doesn't require it. I struggle to see the cogent argument for that position when we're talking about something as fundamental, as intuitive and as simple as this. So if there is resistance, then I hope I can persuade them that really there are very few, if any, that I can identify risks of introducing this type of model that would damage anyone's ability to have a fair trial, in public. We're talking about reporting restrictions here, not secret processes. And I think when you take all of that together, I hope it's a compelling argument for why this is a really important thing to do. And it's an important thing for Scotland to really make progress with sooner rather than later. And that's the argument that Sinead, me and our students are going to be making through this campaign. And if you are sympathetic with that, we're going to be putting out some additional materials over the next few weeks or so in terms of that to help raise public understanding of this as a problem in Scotland, to give you kind of pen portraits of how other countries do this, how other countries deal with this, and also critically different ways we can do it as well. I think that's also important, that there's not just one simple way. We don't just have to copy and paste the English model. We can do something a little bit different, and something which much more clearly focuses and articulates the idea that this is fundamentally, for me at least, rooted in ideas of the rights of complainers in these types of cases. And I think we can frame a Scots law intervention of that kind in a way which is extremely modern and reflects the very best of these international practices.
Thank you, Andrew. Well, I'm certainly very hopeful that change will be forthcoming. We're just at the end of our time and we haven't had any more questions. So I just wanted to let you know that in the chat, Monica and some other people have been putting up some useful links for people, the Dorian Review, some information about the campaign that Andrew, Sinead and the students are doing as well. There's also a link to the SIPR website to subscribe for updates and news. The webinar today was a jointly hosted webinar between the Scottish Institute for Policing Research Public Protection Research Network, which I'm the Associate Director for, and GCU's Justice, Violence and Gender. And I think sometimes people think signing up to the SIPR website everything will be very policing focused, but our work tends to look at a whole range of aspects that are on, for and with and in relation to the police and policing. So for example, our event today. So if you're interested in other things, then feel free to subscribe. We have another one from our network coming up on the 20th of April, which is specifically on child sexual exploitation and use of social network analysis to understand both victim and perpetrator groups, if that's of anyone interests anybody as well. So it really just remains for me to thank Andrew very much for his excellent presentation, and thank you to those of you who contributed to the chat and asked such insightful questions as well.
Well, thanks to everyone also for coming. I always am very grateful. It's always really great. And one of the benefits of, I suppose, of the current context is that we can get so many people from different parts of the country around. So that's been really, I've enjoyed that a lot. Thank you so much for coming and for listening to what I've got to say. Thank you.
Yes, thank you all. Much appreciated.